So the Supreme Court recently granted, vacated, and remanded a concealed carry ban case back down to the lower court, and now this issue is being reevaluated, and the issue of a state outright defying the Supreme Court's Bruen decision is now back on the docket. So let's break down what is happening. Now, really quick before we jump into this video, I want to thank one of the main supporters of this channel, which is Blackout Coffee. Blackout Coffee has amazing coffee, and they're huge Second Amendment supporters. They have dedicated rows for organizations like FBC and GOA, so if you want to get amazing coffee and support a pro-2A company, check out Blackout Coffee using the links down below. And also, if you use the code ARMSCHOLAR, you can get 10% off of your order. Now, as I mentioned in the intro, in this video, we're going to be discussing how an issue of concealed carry and the violation of the Second Amendment requiring permits in hyper-restrictive concealed carry schemes was recently sent back down to the lower court from the Supreme Court. The Supreme Court recently issued an order on this issue, and now this issue is once again being reevaluated because of what the lower court did, and because the Supreme Court has been outright defied, not just by the Court of Appeals, but also the state that put in place this ban. Now, you may recall that recently the Supreme Court had to step in multiple times when it came to the state of New York and the restrictions on concealed carry. There have been multiple cases that have gone to the Supreme Court, and multiple times now the Supreme Court has sent guidance to the Second Circuit and the lower courts about how to handle concealed carry issues. You may recall that also recently there was 5 consolidated cases that were heard in front of the Second Circuit, and they deal with the State of New York's Concealed Carry Improvement Act, also known as the CCIA. That law in New York created a hyper-restrictive concealed carry law, and that was in direct response to what the Supreme Court said in their New York State Rifle and Pistol Association versus Bruen decision. The state of New York passed that law just 8 days after the Supreme Court issued that 6-3 decision. New York did that in direct defiance to that decision, and actually the governor in New York said that that's why they were exactly doing that they were doing that in defiance of Bruen, and they were just going to try to put in place a more hyper-restrictive concealed carry scheme and permit process and restrictions because they did not like what the Supreme Court said. But recently, the Supreme Court granted, vacated, and remanded the case, which was up on cert to the Supreme Court. They sent the Antonyuk case, which was filed by GOA. They sent that case back down to the Second Circuit, which means that they granted review to the case. They vacated what the Second Circuit said prior, and then they remanded it back down to the Second Circuit for them to reevaluate their decision in light of the Rahimi decision. And now the Second Circuit has issued an order, and they have withdrawn their mandate on their prior decision, and they have redocketed the appeal, and they're asking for new briefs in light of that Rahimi decision, and also the Supreme Court granting, vacating, and remanded the case back down to them. Now, for some background on this case and what impacts this has not just on the state of New York, but other states like California. So for context, in Bruen, the Supreme Court struck down New York's original May issue licensing scheme, finding that it was inconsistent with this nation's history and tradition. One of the other really important things that the Supreme Court did is they said that the state of New York and other states could not simply just make everywhere within a certain location a sensitive location. However, despite that decision, New York rushed through the Concealed Carry Improvement Act just 8 days after that decision. And the scheme that they put in place was worse than the one that existed prior. They have more restrictions on where you can carry. They have the whole vampire rule that's attached to this, where you would have to get actual permission from the business or the public location to carry at that location. So instead of them having to put up signs that say, no, you can't carry here, you would actually have to maybe have a sign that says, yes, you can carry here, or you would have to get permission from that business. Now, this law was challenged in multiple cases in multiple district courts, and multiple district courts actually granted preliminary injunctions, which halted the enforcement of various aspects of the CCIA. However, of course, the state of New York did not like that, so they appealed those decisions up to the Second Circuit, who granted blanket stays on those decisions, and then recently heard arguments in those cases and just ruled in favor of the state of New York. There were some aspects that were shot down, but generally it was in favor of the state of New York upholding these restrictions. And that led for the plaintiffs here, a GOA, to then seek multiple times writs of cert to the Supreme Court. The most recent one actually, though, was put on hold, and it sat behind the Rahimi decision because the Supreme Court was set to rule in Rahimi. And so there were a bunch of cases that were put on hold for the Supreme Court to decide Rahimi. Now, if you're not aware, the Supreme Court recently, last term, did issue a new Second Amendment decision in the Rahimi case. That was an 8-1 decision, and Justice Thomas was the only dissenting judge. Now, in Rahimi, they addressed whether or not the federal law laws and the federal restrictions on the possession of firearms and other weapons and ammunition in hands of people subject to domestic violence restraining orders, whether or not that was constitutional or not. And ultimately, the majority ruled that yes, that part of federal law is constitutional. It did not violate the Second Amendment. They looked at some of the analysis. They, in some ways, kept it very hyper restrictive as applied to Mr. Rahimi himself. And they found just that aspect was constitutional. But there was also some discussion about how the analysis in Bruen should really play out. And there's a lot of concerns about maybe how that will impact other cases going forward. But as I mentioned, Antonyuk, this case dealing with concealed carry laws, was placed on hold behind that decision. Now, with Antonyuk in the writ of cert that was pending in front of the Supreme Court, this specific case is known as an interlocutory case, which means it's just simply an in-between case. The case has not been fully decided on the merits by the lower court. It's kind of this in-between stage right now. And typically the Supreme Court does not like to review those type of cases. So it had kind of an uphill battle, but ultimately, which one of the positive things that happened is that we got an order list from the Supreme Court and they decided to just not deny the case. Instead, what they did is they issued a GVR, which is a grant, vacate, and remand of the case. And they remanded it back down to the Second Circuit for them to reanalyze the case in light of what they just said in Rahimi. Now, I will say one of the very intriguing things about the Antonyuk case is I don't necessarily see how Rahimi will change any of the lower court analysis when it comes to the CCIA. This Second Circuit panel and this Second Circuit review has already shown that they will try to limit the win as much as possible, even when it came to, striking down the catch-all provision, the vampire rule in the CCIA. That was really the only section that they found big issues with, but all the other sections they upheld. And I don't really think anything in Rahimi is really going to change that, because you also have to remember that Rahimi, of course, dealt with a different issue dealing with domestic violence restraining orders. But also Rahimi, that analysis and that discussion of Bruen, in my eyes, didn't change a whole lot. And if anything, added some unfortunate language that a court like the Second Circuit, of course, is going to try to use to justify whatever gun control that they want to uphold. And I think if you have a bad circuit court or a bad panel on one of these courts, like the Second Circuit, the Seventh Circuit, the Ninth Circuit, any of those, if you have a certain panel, they're going to try to pull language from Rahimi to justify whatever they want. For example, Justice Thomas in his dissent wanted to keep a very limited and tight interpretation of Bruen. Of course, Justice Thomas was the author of Bruen, and what he was advocating in his dissent in Rahimi is that he wanted to keep the analysis, the text, history, and tradition analysis, as limited as possible to avoid any, wiggle room arguments. And I think what you're going to see probably in this specific case, Antonyuk, is when the Second Circuit reevaluates this case, if anything, I think they're going to probably rule the same way. I wouldn't be shocked if they just issue a very similar argument or a very similar decision. But again, this is one of those things that's evolving because of that GVR from the Supreme Court. And now you have the Second Circuit that issued their order saying that they are pulling the mandate that they issued prior because, of course, their judgment was vacated. So that's one of the things with the GVR is the Supreme Court vacated their prior decision. So the Second Circuit had to pull their mandate, and then they notified that, hey, we're going to take this up on appeal again, and that we are going to rule on this again. And they've ordered the parties to submit briefs and arguments in light of Rahimi and how that decision from the Supreme Court is going to impact this issue. So that's going to be something that's going to be very interesting to see how that develops at the Second Circuit level. It's going to be interesting to see how the state of New York argues this. I would anticipate in their briefs, they're going to say that Rahimi justifies what the Second Circuit did before. It justifies the CCIA, that Rahimi's maybe looser historical analysis, justifies this type of restriction. So I have no doubt that those types of arguments are going to be made. I would anticipate that the awesome attorneys over at GOA are going to combat that, saying, hey, Rahimi doesn't really change anything. If anything, it just affirmed what the historical analysis was in Bruen. Nothing should be changed. So now we're going to see this develop at the Second Circuit, but this is something very important, not just for the state of New York, but also states like California. But of course, if anything else changes, I will let you guys know. Also, if you guys would like to support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm, and it signals to YouTube that you guys see value in these videos and in this type of 2A news. But as always, thank you all for watching. Don't forget to like and subscribe, and never forget this nation was built by armed scholars, and this nation will be maintained by armed scholars.